Thank you very much. Thank you for having me.
So here you are in the wild world of the Robert Jackson Center and Chautauqua Institution, of which Jackson spoke here frequently, just to give you a sense of historical perspective. And how'd you get into this crazy business?
Well, I was initially out of law school. I went into the U.S. Navy JAG Corps, and as I was in the JAG Corps, the war in Bosnia was really hot and really occurring, and then they set up the ICTY, the International Criminal Tribunal for the former Yugoslavia. I was still in the Navy, but I was very, very interested in that type of work, that international humanitarian law aspect of the law. And so I ended up leaving the Navy in 1995, 1996, and I went and did an LLM in London at the London School of Economics, and I knew this was exactly the kind of work I wanted to do. It was a bit anxiety-ridden at first. My wife just became pregnant right as I started the one-year LLM program. I had no job, but I was determined that I wanted to work in this field. Yeah. And of course, there were really only one or two places that were doing this kind of work at the time, the ICTY and the ICTR.
One just doesn't announce that they're going to be in that field. I mean, was there some tipping point in your life that said, aha?
Aha. I think it was a combination of things, actually. I wasn't a typical kind of law school student. I didn't go to law school to really be a lawyer. I was initially interested in the field of arms control. I was very interested in international security policy. I was very interested in this aspect of work. I had a college advisor who'd been heavily involved with the U.S. Arms Control and Disarmament Agency and doing a lot of the arms control work in the 70s. And he said to me, all those guys have law degrees. If you want to go and be an arms control negotiator, you want to be involved in arms control, get a law degree. So I actually went and did a joint degree at Columbia Law School and with the School of International and Public Affairs, and did a master's in security policy and a law degree. And that's really what I wanted to do. Yeah. Just as I was finishing, of course, the Cold War ended, and all of my classmates who were studying on the security policy front just were, what are we going to do now? And so I had the law degree kind of to fall back on, and so that's when I made the decision, well, I know that there's a lot of interaction between international relations, security policy, and the law and the military, so I started looking at the different military JAG corps and found that I really enjoyed, once I was in the Navy, I really enjoyed the courtroom aspect of it. So that kind of then led me to think, well, I want to do something a little bit bigger than military justice. I want to be doing something in the bigger, broader world. And as I said, then as I'm doing this, as I'm just starting to kind of practice in the U.S. Navy JAG Corps, the war in Bosnia really took off, and the tribunal was established, and it was very clear to me that's exactly the kind of work that I want to do.
So you work directly with Goldstone? Richard Goldstone?
I got there. I initially went and worked for with the judges in the chambers, and I worked for Gabrielle Kirk MacDonald, the U.S. judge who was the president. I actually happened to meet her at a conference in London while I was still doing the one-year LLM, and I made it very much a point during one of the breaks in the conference to just go up and introduce myself to her, and as I did that, one of the first things she said when I introduced myself, and she said, well, what's your background? And I said, well, I was in the military and I've left, and she just kind of stopped and she said, you're a military lawyer? And I said, well, I was a military lawyer. I've left. I'm now doing this graduate program. And she said, but you're a military lawyer? And I said, well, I was, but I've left. And she said, I've been looking for a military lawyer. Would you be interested in coming to work at the tribunal? And I thought, well, that's exactly why I'm here at this conference, to meet people and try to get in the field. So kind of one thing led to another, and as soon as I finished the LLM degree, I moved to The Hague and started working for Judge MacDonald. I was with her for about 19 months, and then she retired from the court, and it was very clear then that the place I really wanted to be was in the office of the prosecutor, and so they had 2 vacancies at the time, and I, it was an internal applicant, applied for those posts, and got to the OTP in November of '99, and was very fortunate as a junior lawyer there to be assigned to, the way the office was then structured, they had a senior lawyer and a junior lawyer on each case, and then lawyers who'd worked on the actual investigation joined those two to become part of the trial team. And so I was assigned to a senior trial lawyer from Canada, and within 2 months of joining OTP, I was in the courtroom in a trial, and I was involved in 7 or 8 trials there before I left in August of 2009 and went to the Special Tribunal for Lebanon.
The Serge will hopefully be here.
Weather
He's out of
permitting.
New York City here soon. That's one of those tribunals that was the first and continues. And because of the recent arrests of Mladic and Karadzic, is there an end game in all of this, given financial constraints and other things?
Yeah, I think that's always an issue for all of the ad hoc tribunals and hybrid internationalized tribunals. The funding issue is always a very serious and significant hurdle that they face, on top of all of the legal challenges. I think now what they're looking at the ICTY is finishing in about 2014 or 2015 with the appeals from ultimately the Mladic and Karadzic trials, and hopefully Serge will be here, and you can put those questions to him for the more up-to-date information.
Right.
But I do think, I think that really, having been the first of the international criminal tribunals to be established, the ICTY really has set a very, very high standard for other international courts and tribunals to follow. I think that the jurisprudence and the work that we did there was generally speaking very high quality, and I think it achieved a number of the goals which the international community really set for the court. Not to mention the fact that I think a number of experts and diplomats and scholars would all really say that there wouldn't be an international criminal justice system had the ICTY not succeeded in its early years, and at least demonstrating that it was possible to do this.
What were some of its goals, and what did it achieve?
Well, I think it you know, when we talk about deterrence is always a very difficult thing, and it was the same thing I remember studying deterrence when I was studying arms control. You never know what you didn't deter. You could always say, well, the ICTY did not stop the genocide in Rwanda. The ICTY did not even stop the genocide in Srebrenica, because the ICTY was up and functioning at that point in time. But I do think that certainly by now, there have to be you know, dictators and despots around the world who do fear being brought to justice, and there is that long-standing clash between you know, international peace and justice and stability, which is one that I don't think international courts are by themselves ever going to resolve. Obviously, those of us who work in the field, and particularly who are prosecutors, we generally have very strong views on that debate, just as the diplomats who sit down in peace negotiations have very strong views on the fact that you know, it's very difficult to get someone to back down in a conflict situation if the likely result is they are going to be in the dock in The Hague for prosecution for war crimes or crimes against humanity or even genocide. So there is that inherent tension. But I do think that the ICTY, again, as the first one of these courts, really did go a long way in changing the mindset of people that say that these kinds of courts could be up and running and established. I also think that although obviously you'll find differences of opinions on this, I do think that the ICTY played and plays an important role in reconciling the different groups within Bosnia in particular, but within the greater former Yugoslavia as a whole. I remember once all three of the entities within Bosnia had ambassadors or liaison officers to the tribunal. So we had a Bosnian Muslim liaison officer, a Bosnian Croat liaison officer, and a Bosnian Serb liaison officer, and they would all periodically come, quite frequently actually, to the ICTY offices and talk to the principals. And the general consensus was they were all complaining about something. And Judge McDonald at one point said to me after a round of meeting these three individuals, always separately, of course, she said, well, we've managed to piss them all off. I think we're doing something right. And so it really was a sense that they all did feel that we were targeting their own nationals, not prosecuting enough cases where their side were victims. But I will say, and I'm one of the few, if not the only, ICTY prosecutor who prosecuted all three sides in the conflict, that clearly there were victims on all sides to the conflict in Bosnia in particular, just as there were perpetrators on all sides. This is not a clear-cut situation where one side committed all the crimes and one side was just victims. So I do think it's important that historical record go out, that there were you know, crimes committed by soldiers of the Army of Bosnia and Herzegovina, the predominantly Muslim army. There were crimes committed by the Bosnian Croats, and there were crimes committed by the Bosnian Serbs, and all of those different communities were victims of that conflict as well.
You talk about the record. Plus, you always hear the disappointment that everybody had with the premature death of Milosevic trial. I've always been confused because clearly the trial went for an extended period of time. There is a record. Does that not alone provide some benefit of at least pride that there was this opportunity for everything except really judgment?
Yeah, I think the key point is just what you said at the end. There isn't a judgment, and so many people will view that as being a disappointment. In terms of setting a historical record where the victims and witnesses could come into a courtroom and testify and face cross-examination for what they witnessed or what they experienced, I think in that sense it was something that should be viewed more positively than it was. Simply the fact that you don't have an end result does not mean that there's a lack of a historical record as to what happened and his role in that.
That's always it's always been, because I look at the Nuremberg trial, yes, there was a judgment there, but the reality is you always kind of go back to the evidence, the transcripts, the Holocaust. That's what you go back to, and you still have that. Yeah,
I think historians in particular will probably view that more richly than will lawyers, for that very reason. The historians can go back and read the transcripts, look at the evidence, look at the exhibits, look at the material that was admitted, and they still have a pretty solid record upon which they can do their work. Lawyers, of course, only want to see that judgment. What was he found guilty, and if so, on what counts? So from that viewpoint, lawyers, of course, also looking at precedents. It's a little bit more difficult, I think, for a number of lawyers to work with than historians. But it is there. Yep. The record is there.
The ICTY, of which you were such a part, always were looking for the Mladic, the Karadzic. Did you know where they were?
I think we had a pretty good idea throughout where they were, what areas they were operating in. That's not to say that there was a lot of real-time intel that we knew on Tuesday at 3:25 he was at this address. But the general areas where he was operating and where they were, we had pretty good information as to where they were.
So do you get a sense it was just a function of political will?
Yes.
And so when the European Union sort of put the squeeze to them,
it tends to be that way. Either the European Union puts a little pressure on, or, as was the case with Milosevic, the U.S. government put a lot of pressure on them in terms of withholding funding, and so it tends to be either economic or political pressure that gets the states to actually do what they have an obligation to do and a moral obligation to do.
You're the chief of prosecutions at the Special Tribunal for Lebanon. And talk about political will and governmental involvement. Your tribunal is in the eye of that storm right now.
Yeah, we are definitely in the eye of the storm. As you know, sitting here end of August 2011, indictments were just released 2 weeks ago and made public. And
by the way, just the record, against whom?
We've indicted 4 individuals, Mustafa Badreddin, Salim Ayash, and 2 other individuals named Sabra and Onisi, whose role was limited to a diversionary tactic. Badreddin and Ayash were the real ringleaders of this assassination of Rafi Hariri, which killed 21 other individuals and wounded more than 230.
Rafi Hariri was
a former prime minister of Lebanon, and so we're really looking at it as the first real international court or tribunal dealing with the international aspect of terrorism. Of course, there have been domestic prosecutions for terrorist-related offenses, but none really at the international level. Obviously, we rely, as do all of the international courts and tribunals, to a great extent on national authorities for assistance, whether it's providing us with evidence, making witnesses available, or the all-important making arrests of individuals that have been indicted. As of right now, the Lebanese government has been unable to arrest these 4 individuals. The president of the tribunal, Antonio Cassesi, a real leading light in the field, and is now the president of the STL, has given the Prosecutor General of Lebanon, who's the authority responsible for undertaking the arrests, has given him additional time to try to make those arrests. It's not very likely that the government of Lebanon will be able to do that. I think it's not much of a secret that within Lebanon there is basically a state within a state that's controlled by Hezbollah. These 4 individuals are affiliated with that party, and they've said repeatedly, Hezbollah has said repeatedly, that they will neither allow them to surrender nor tolerate them being arrested. Hassan Nasrallah has said even for 300 years we will not cooperate, we will not allow these people to be arrested. And so I think it would be a very tragic situation if attempts were made to arrest them, which resulted in further bloodshed or civil war even in Lebanon. But my sense is that they're in areas of Lebanon that are completely controlled by Hezbollah, and which the government simply has no ability to even enter and to make the arrest. So I think partially our tribunal was established at such a time there were 4 other individuals who were held in captivity or who were being held in pretrial detention for this offense. As soon as the tribunal was established, they were let go because of lack of credible evidence against them. But I think that one of the things that makes our tribunal unique from the others is that we do have provisions in our statute and rules for trials in absentia, and I don't think really many of us coming from common law jurisdictions are comfortable with that notion, but we do have that in our toolbox, and it's looking increasingly like we will be conducting a trial in absentia, which has its own procedural safeguards built in. All of the accused will be entitled to legal representation. They're entitled to a retrial at any time prior to judgment by simply showing up and demanding one. And I think any time in the future, if they were to be arrested, they would also be given an opportunity to challenge the results of the trial in absentia judgment against them if they were to be found guilty. So we've kind of got a built-in huge issue when looking at our residual mechanism at such point in time when we close up shop like the other ad hoc tribunals.
You'll have the door opened a little bit?
Our door will always be a little bit more ajar than some of the other courts and tribunals, particularly as is the case with the ICTY now that they've gotten Goran Hadzic. The ICTY has no further outstanding arrest warrants for anyone. The ICTR has still a handful, a few. So our door will still be, I think, a little bit more ajar than the others. It's very unlikely at this point that we would get them, and I think it's even more unlikely. I know there were a number of us who at the ICTY always could envision a situation where Mladic or Karadzic would be arrested. It's very, very difficult for anyone working at the STL to ever even imagine a situation where that would be the case.
Do you get a sense from a government perspective, I know you used the term unable, are they unwilling also?
I think they've demonstrated, at least in their statements, that they're willing, and I do know based on what was done within the first month of the arrest warrants being issued, what they did. Whether those steps were completely reasonable, whether that was all they could do, I don't know. It's very difficult for any of us to kind of pierce the veil and really be on the ground and say, yeah, they could do this, they could do that. But the president has gone back to them and given them an additional 30 days with some further suggestions that were made by the Office of the Prosecutor in terms of what we thought might be some additional reasonable steps that they could take. So I think they've at least publicly stated a willingness. The government has publicly stated a willingness to do that, and they have taken certain steps. But again, in order to trigger the trial in absentia, the trial chamber must be persuaded that the steps that they did take were reasonable under the circumstances. And I'm not sure at this point that a trial chamber would make that determination. We'll have to just wait and see what they do in the next few weeks. I would expect this issue to come back before the trial chamber sometime towards the end of September 2011 for a decision, and we'll see what happens after that.
When you hear the term absentia in my world, I flash back to Nuremberg and Martin Bormann.
Yeah.
Has there been other trials in absentia?
No.
So that's the precedent?
There have been none of the other international criminal courts allow for it. Otherwise, we would have seen the work of the ICTY finish much earlier, and the ICTR as well. They simply would have, had they had the statutory and legal-based ability to do that, I'm pretty confident that they would have face, you know, in light of the enormous pressures that they face to finish up their work and move forward. So yeah, we'll be really the first modern international criminal tribunal that has this this tool in the toolbox, so to say.
Obviously, they anticipated this issue to even put it in your toolbox.
Yeah. Yeah, it was one that I think it was not so much that they necessarily anticipated it as being something particularly relevant to our tribunal. I think they were looking at it also, and that was there, but I think they were also looking at it from a potential possibility of not wanting to be running for 15 or 20 years. We weren't going to have another waiting for Karadzic, waiting for Mladic tribunal that could just go on, you know, for 20 years, costing you know, significant amount of money, only to have a result where they were never arrested. So it was partially the bigger picture, having seen what the other, particularly ICTY and ICTR had gone through. But there was that possibility. I think it doesn't take much of a stretch to look at any kind of terrorist attack, particularly of the size and scale of the attack that killed Rafi Hariri on February 14, 2005, to realize that there might have been some state involvement, outside state involvement with that. And if you're looking potentially at indicting heads of state, sitting heads of states, we also know from the experience of the ICC how difficult it is to actually get a sitting head of state out, you know, arrested and in custody. So I think they were also thinking of the possibility for some kind of state head of state being involved in that or having knowledge of that attack, and so I think that was probably also a factor. So I think it was really those three kinds of issues that they were looking at when they included this.
We're talking about Martin Bormann and Nuremberg. What does a Robert Jackson mean to a Daryl Mundis?
Yeah, I think there's certainly a couple of really big names of people from the Nuremberg Tribunal or the subsequent Control Council Law Number 10 cases that really come to mind in terms of being inspirations, and Robert Jackson, of course, is right at the top of the list. I mean, I think all of us have read, you know, his opening and closings. We've all seen movie clips of his work, and just to have the sense of where he came from, with his kind of meteoric rise in New York, followed by in Washington. I think he's just truly a really inspirational type of figure for a number of people working in the field. He's certainly right up at the top of the list of a number of us who work in the field and kind of view him as heroes. Of course, Ben Ferens being a very active, surviving Nuremberg prosecutor from Einsatzgruppen trial is another one. And I tell Ben that every time I see him. I remind him, you know, you're a hero. You're my hero. So there are, you know, unfortunately only a couple of them left. But certainly Robert Jackson, just from his ability as an orator, his ability, just numerous, you know, things. He was quite a capable individual. Particularly when you realize he didn't even graduate from law school.
Yeah. Never went to college.
Never went to college. No. Very different era in terms of legal training, but it's also just astonishing. And I'm also from a rural part of the U.S. I think it's great anytime, you know, small town boy makes big is also just part of the whole American dream, really. Lebanon.
You know, trial will start when?
We expect the trial will probably start in the late summer or early autumn of 2012. Based on the projected timelines that we're looking at. You know, first thing will have to be a decision that there'll be a trial in absentia. Then there'll have to be appointment of counsel. Then we'll go through a number of preliminary motions, challenges on defects in the form of the indictment, challenges to the legality of the establishment of the tribunal, just as the ICTY had in Tadic and the ICTR had. We'll have to face a number of those preliminary motions. We'll have, obviously, disclosure obligations where the prosecution will be disclosing all of its evidence. The defense will be reviewing that. We expect the trial to start in late July or perhaps September of 2012.
as designated as the chief of prosecutions, what's your role?
Yeah, we're structured very similarly to most of the other international criminal tribunals. We have the chief prosecutor, Daniel Belmar, and then the office is divided into two divisions, the investigation division and the prosecution division. And in addition, there's a very small immediate office that includes staff working directly for the chief prosecutor. The investigation division, as you can imagine, has all of the investigators, all of the analysts, and basically responsible for going out into the field, gathering the evidence, analyzing that evidence, and kind of packaging it up and providing it, to my team. And I have within the prosecution division all of the actual line prosecutors who go into court. I have a number of legal advisors, Lebanese law advisors, and then we have a disclosure team that will be responsible for disclosing all of the evidence to the defense. So I basically have all of the lawyers within the office working for me.
Wow.
Yeah, it's a big operation, but it's very typical. That's very typically how the offices are structured. You've got below the chief prosecutor, perhaps a deputy. We do have a deputy prosecutor who's based in Lebanon, which is also different than the other tribunals. So the deputy prosecutor is in Beirut, and then our office is actually in Leidschendam, which is a suburb of The Hague, and both the investigation division and the prosecution division are based at the headquarters. We have a contingent of 7 to 10 people at the field office in Beirut that includes some investigators who can go out and gather material on short notice. Otherwise, we send investigators from headquarters.
Is it hard getting witnesses?
It is a bit difficult. It's always a challenge. I think most of the international courts and tribunals, it's not always easy to get witnesses. We face, of course, the additional hurdle that we're proceeding against a terrorist organization. Mm-hmm. But we haven't run into significant problems in terms of getting witnesses who will agree to cooperate with us. And so we have been fortunate in that we are able to still get witnesses who will agree to come forward and testify. Quite often, it's given the nature of the case, and it's largely a circumstantial case. You get a witness who will testify about a very, very small sliver of the case, which in isolation might not mean all that much. But it's when you put all of those various witnesses together that pictures emerge, and it's pretty compelling, the entire evidentiary package we have. As is the case with the other tribunals as well, we will be in a position to, if we can justify it to the trial chamber, and after allowing the defense to be heard, it is possible for evidence to be admitted in terms of written statements as well. So some of the witnesses, we might be just leading their evidence by way of their written statement, making them available for cross-examination, or even foregoing cross-examination if the witnesses are unable to be located or can't be located, or due to security concerns just absolutely refuse to testify. So we do have a number of ways of getting that evidence in addition to bringing the witnesses to testify. But so far, we haven't gotten to the stage of finalizing the witness list. We're working on that right now, and then we'll have to cross the bridge in terms of whether the witnesses actually come and testify. But we haven't had a significant problem where witnesses have refused to sit down and meet with us, other than, of course, some witnesses who are members of Hezbollah and who always seek instruction from the party if we send them a summons to appear, and sometimes the party has said, no, we're not going to let you interview these people, and the witnesses actually seem to follow suit on that. But we've got a number of witnesses who've provided us with statements, and at this point we still continue to believe that they will come to The Hague and testify when called to do so.
As you step back, because you currently are in the eye of the storm, both politically and legally, and cases, and you look at the other tribunals, and you look at the history of the tribunals, because you were virtually there at the beginning, 1991, and here we are, 2011, and ICTY, we got Rwanda, we got Cambodia, certainly those hybrid courts. Are you able to step back enough to say, gee, various tribunals, various hybrids have gone along, but they're all kind of winding down, and when the day is done, either they wind down voluntarily, or in some cases maybe economically they just say, we're going to throw you to the winds and be done with it.
Yeah.
Is there Is there a message in all this? Is there a legacy of all this?
Well, I think it's important to understand that the international criminal justice system, before the ICC was really up and running, the only real option was for these ad hoc tribunals, and it also covered situations which, once the ICC was established, if there was something outside the jurisdiction of the ICC, the only way to pursue it would be to have an ad hoc tribunal, something along the lines of the Special Court for Sierra Leone or the ECCC dealing with crimes committed by the Khmer Rouge in Cambodia, or the Special Tribunal for Lebanon. For various reasons, none of those conflicts or terrorist attacks, in the case of my court, would have fallen under the jurisdiction of the ICC, and so the international community made the decision that they felt it was important to do this. This entire system of international criminal justice is expensive, and it's time-consuming. And it is a bit frustrating for those of us who have to deal with the states that provide the financial support to have to keep going back to them and asking for more money. It's unfortunate that realization wasn't there at the beginning of the process. I think the states now have enough experience with establishing these courts and funding them that they realize how expensive and how lengthy the process is. And I'm sure that's a contributing factor to what we refer to as tribunal fatigue among the international community states, particularly that fund and support the tribunals. But I do think it's important, because of the limited scope of jurisdiction of the ICC in terms of being forward-looking, and given that it doesn't necessarily cover all of the various international crimes, terrorism being a classic example, that we do try to keep the door open for future tribunals. There was some discussion, I understand it's now been completely closed off, of a piracy tribunal dealing with crimes committed by pirates off the coast of Africa. I think that would have been a very interesting endeavor. It would have been a very costly endeavor, and I understand that. But at the same time, I mean, I think if you consider the costs, which given the current global economic situation, which is not a good one, I would still make the argument that the costs of running these tribunals is really minuscule compared with some of the value that is obtained from bringing people to justice. I do think, as I mentioned before, it's hard to determine whether there's a deterrent effect, but I would still argue that the costs that are involved are minor compared to potential costs if we were to stop pursuing people by way of an international criminal justice system. So I hope that the ICC continues to have the resources to continue doing the important work that they're doing. But I don't necessarily think that we should foreclose forever the possibility of future international criminal tribunals, because I do think that, as costly as they are, in the long run, they might be viewed as being cost savings compared to what would happen in the absence of such international courts and tribunals. I mean, yes, the Special Tribunal for Lebanon costs $65 million a year. That's a lot of money. On the other hand, if it has contributed in any way, shape, or form to slowing or perhaps halting in some places the spread of terrorist attacks, foregoing the need for U.S. military or NATO to send boots on the ground somewhere to stamp out terrorists, I think the cost is just a drop in the bucket in terms of the potential costs involved. So I think we need to keep an open mind about the costs of these things. They are tremendously expensive, and again, the current global economic situation is not one where you can just set up a bunch of tribunals that will cost $100 million a year to operate. On the other hand, when spread across the international community, some of these costs are certainly manageable.
Sorry for that interruption. What's next for you? If you had to forecast out the next 5-10 years, I think you've sort of projected a little bit on the shelf life of the Lebanon Tribunal. You've been in this business for 20 years. You want to stay in this business?
I would certainly like to stay in the business. I enjoy it both professionally and personally. It is a difficult business to be in. I would expect that the work of the Special Tribunal for Lebanon will take probably another 3 to 4 years to finish. So kind of in the short-term picture, I would imagine being in the field for another few years at the very least. We'll just have to wait and see really what might come next. I'm realistic enough to know that as all of these international courts and tribunals close down, they're going to be disgorging a large number of highly experienced individuals. I think a number of us would like to continue being of service in whatever way we can in this type of work. Going hand in glove with what we just were speaking about in terms of the likelihood of future international criminal tribunals or courts being established is very, very slim. But I do think that there will probably be continuing needs for hybrid or internationalized courts that are much more of a short duration in terms of temporal involvement of international community. They'll send, perhaps send a team of individuals in to help for 12 to 18 months reestablishing justice systems in regions of the world or countries where perhaps they are not states party to the ICC, and therefore the conflicts wouldn't be ones that would be tried or prosecuted before the ICC. So I think there's some opportunities there as well. I think it's very much it's a very addictive type of work. I know a number of people who, for whatever personal reasons, have decided to go back to their home countries, and then 3 or 4 months later they're calling on the phone. Can I come back? Can I? Yeah. You got anything? I'd like to come back. I miss the line of work. So I'm realistic enough to know that I think I have that bug as well, and so I would it would be very, very difficult for me to leave this line of work. But I am realistic enough to know that a number of opportunities that existed in the past probably won't be there. So we'll look at other things when the time comes. Teaching is always of great interest. My father was a professor, so it's a lifestyle that I think I could adapt to quite easily.
I've always been amazed by individuals like you who are so passionate about this area of law and continue to stand it, because I know it's not a get-rich-quick opportunity, yet there's a higher calling here, and I sense it in you, and I've sensed it in others. It's really quite remarkable. You're to be commended.
Well, thank you. I mean, what is both really empowering, but also to be honest, part of the difficulty of doing this kind of work day in and day out is dealing with the victims. You can get such a sense of power from these people when you sit down and listen to them, and what they've gone through really can be used as a driving force to move you forward in terms of keeping you energized and keeping you enthusiastic about what you do. It's really all about, down at that level, it's really all about bringing justice to these people, many of whom come from very, very poor and faced tremendous crimes committed against them and their families, and so you take a lot of energy from them in that sense. But it's difficult dealing day in and day out with victims as well. It can have a toll on you, and you need to be aware of that, and you need to be able to step back and take enough time that you don't become so embroiled with it that you take on too much personally, and I've seen that actually happen to colleagues as well. So it's an exciting line of work. I think I speak for a number of us. If I didn't have in a few years children to put through college, I'll tell you, I would pay to do this kind of work.
Yeah. Well,
it's a big secret. don't like to say that too much. If I had the financial means to pay to do this job, I would do it. So I want to again thank you and everyone at the Jackson Center. I think it's tremendous these dialogues that you run, and carrying forth the legacy of Robert Jackson, I think is also a really important job that you do, and I want to thank you for hosting these events and for bringing me here.
Well, it's great for us because I get a sense that you don't get together much.
No.
And certainly here at Chautauqua, it's definitely not easy to get to, but once you're here,
it's great.
Yeah. Just a sidebar. I noticed that one of the big positions in your field is up for conversation, and that is, of course, Luis Marino Ocampo's successor. Are you able to handicap who's the likely successor?
Stick my neck out on this one. No, I think most likely there's been a lot of pressure from the African Union for an African to do the job. I think Fatou Bensouda, the current deputy prosecutor at the ICC, is very highly experienced and very well motivated. I would put my money on Fatou at this point in time. There are a number of other really good candidates who've expressed an interest in the position, and I'm sure any of them would also be very good in the job. But I do think it's important, particularly given the number of cases and situations coming from Africa and the potential for further problems coming from the African Union if there weren't an African chief prosecutor. And again, I say that with the greatest of respect for Fatou Bensouda, and who's someone who's worked in the field for many years and is highly experienced and highly qualified to do the job. And so my sense at this point would be Fatou probably has the best chances, and deservedly so. I think she'd do a wonderful job.
Well, we can ask her, because someplace in between there and here she is. May or may not get here, but that's her.
Yeah.
Well, thank you. This is great, Daryl.
No, my pleasure. Thanks.